you've obtained a performance license to read a book in a public setting, does that also cover a recording of that being put out on social media by you or by some other person who happens to be in the audience? Today, we're breaking all that down and more with everybody's favorite IP and entertainment lawyer, Tony.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called the IP Professor that is dedicated to all things intellectual property.
Tony, recently we've been talking about performance licenses for people reading books in public settings. But what happens if we obtain a performance license and then somebody is going to film that and put it out on social media? Do we need extra licensure? How does that work for us?
Yeah, that's a fantastic question. It's all going to boil down to what the essence of the performance license even says, what permissions are being granted. Usually when you get those types of licenses, you're given a certain set of instructions, certain list of permissions. And I should add that the performance license that Cam is talking about is kind of a bit different than, let's say, the type of a performance license you would see, let's say, in the context of music, where, let's say, there's a public performance of an actual song or series of songs. But the essence of those types of agreements almost operate exactly the same way. So it lays out essentially the do's and don'ts of what you can and cannot do once you've required that permission. So for example, if let's say there was some library that wanted to host, let's say a series of children's book readings. Let's say they decide to go for Dr. Seuss on this given day. And they go through the Dr. Seuss estate, they get permission, they go through the publisher, they get permissions, and it's all laid out, let's say, in some type of license agreement. The license agreement would essentially lay out what exactly the use is for. So more likely than not, you're going to get language that would say you're allowed to do a public reading of Dr. Seuss books for this specific event on such and such date, and then lays out maybe a license fee, other terms like your typical boilerplate provisions that are found in a license agreement. In that language would have to be some type of, statement, if you want to call it that lays out what happens if somebody recorded it, or is it even allowed for somebody to record or live stream it. Naturally, it just popped in my head. Let's say the library in question wanted to do not an entire streaming of the readings, but let's say they wanted to do like a little snippet, post it up on Instagram Live or something, and it would live in perpetuity on Instagram for that library's Instagram page. Is that type of permission allowed? Oddly enough, that would be a very specific type of media distribution right that you would have to ask for upfront with the publisher before you even go any further. So the library can't even necessarily can't even just do it on their own. They have to ask for permission first with the publisher, and even with, in this case, maybe the Dr. Seuss estate, if that's allowed, because that might trigger an additional license fee, and you have to be pretty honest and candid about that. So if language is essentially absent regarding that, there are two things you could do. One, don't encourage it. And then two, just ask. I think that's the most reasonable thing to do. You can always follow up with an email and say, hey, we just contemplated after the fact, maybe we want to do an Instagram Live, just a short tease of it on our Instagram page. Is that okay? Or maybe you could even follow up and say, there might be parents that want to record video of their kids watching, and may want to record significant portions of the screening of the reading that we're going to have in today's session. Is that allowed? And the worst that they'll say is no, but the best that they could say is yes. Now, one thing on that point, actually, let's say that there's a parent that did like a 15-second video on Instagram where they show the kid and then they pan over to the reading. In my opinion, that's totally okay, because I think that would qualify in a very unique sense as fair use, because you're kind of providing, first, you're not showing the entirety of the work, you're just showing a very small portion of it, and then you're not really directly criticizing or commenting on it, but it's almost like the video speaks for itself, where it's the kid listening to the reading of a Dr. Seuss book. So in my eyes, that would qualify as fairly good for use in that context. So all in all, I think all that to say, it's at the end of the day, important to get some type of permission about these types of live recordings of any readings in any public setting.
So the best thing that we can possibly do right now is to get that permission up front so we know what we can and cannot do. If, however, you come up with some great ideas after the fact, it's always a wise choice to be reaching out and make sure you have that protection and that coverage before you put anything online after the fact. If you have further questions on any of this, go ahead and drop those down below. And as always, you can reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can listen to my brand new entertainment law podcast called End Scene, released every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Hit the subscribe and notification bell so that you do not miss out on any of these episodes with Tony to make sure that you're legally protected inside of the publishing industry. And if you have further questions, let us know what they are, because Tony's coming back every single week for new episodes to make sure that we're keeping you on the legal up and up when it comes to publishing, writing, and reading. We'll see you in the next episode.